Good afternoon. Welcome to today's webinar, Negligence in Acute Care Hospitals, Evaluating Corporate Responsibility. During this webinar, our presenter will cover the following: the fiduciary duty and responsibility of the CEO and the governing body, the non-delegable accountability of the Chief Executive Officer, how national community standards establish minimum expectations for all hospital activities, the ramifications of the CEO's role in overseeing medical staff activities, and the hospital's responsibility for the clinical practice of medicine by physicians in geographically-based hospital departments. Today's webinar will feature Arthur Shorr. Arthur is the president and founder of Arthur F. Shorr and Associates, consultants to healthcare providers, a management consulting firm specializing in providing operational consulting, business, and strategic planning services to hospitals, medical groups, and physicians. Mr. Shorr also serves as an expert witness in the matters of corporate negligence and institutional liability of hospitals, nursing homes, and licensed healthcare facilities. Mr. Shorr holds an MBA in healthcare administration from the George Washington University and a Bachelor of Science degree in accounting and economics from Brooklyn College, City University of New York. He is board-certified in healthcare administration and is a fellow of the American College of Healthcare Executives. Mr. Shorr has been active professionally in the healthcare field for over 30 years on a full-time basis. He has held senior executive positions in major medical centers, including Cedars-Sinai Hospital, serving as the Vice President of Administration and Chief Operating Officer, the Mount Sinai Medical Center, Milwaukee, Wisconsin, where he was Administrator and Chief Operating Officer and acting Interim President and Chief Executive Officer. He began his career at Hutsville Hospital, a 400-bed teaching component of the Detroit Medical Center. If you have a question that pertains to the presentation, we ask that you use the chat or the Q&A features, which are found here on the right-hand side of the screen. I'm pointing them out with my red arrow. Arthur will do his best to answer your questions during the two Q&A breaks that we're going to take during the presentation. Tomorrow morning, I'll send out an email with a link to the archived recording of this webinar, and we do ask that you take time to fill out the survey that will appear on your screen after the webinar is over. I now invite you to sit back, relax, and enjoy. I'm going to now turn it over to our distinguished presenter, Arthur Shorr. Arthur, it's all yours.
Thank you. Good morning, ladies and gentlemen. It's indeed a privilege and a pleasure to be here. I've done a number of speaking engagements and a few webinars over the years, and I'm happy to be able to reach out to you this way. This presentation today is somewhat atypical, assuming that the majority of the audience are attorneys. Notwithstanding that I've spoken to attorney groups many times, the presentation you're going to see today has its roots and its history in presentations made within the healthcare industry to CEOs, trustees, and actually at a senior presentation of the American College of Healthcare Executives. So the prism through which this presentation is being made is through the, and you'll have to excuse me, there's a little noise that'll pass outside my door in just about 10 seconds. I apologize for that. It's seen through the prism of healthcare executives. But given that the audience is actually principally attorneys, what I really want you to do is appreciate that you're seeing something from inside the healthcare industry. The seminar, as viewed by attorneys, if you're a plaintiff's attorney, the challenge for you in looking at this information is to realize exactly how high the bar is that you have to overcome in order to have a valid claim of corporate negligence or negligence against a healthcare facility. For the defense bar attorneys that are here, it's really a sense and an education as to what you have a duty and a responsibility to understand your client to be meeting. And it's against those standards that you need to evaluate the efficacy of the position you're arguing, notwithstanding your duty and responsibility to your client. Now, the underlying philosophy of everything I've done over the time I've served as an expert and as an educator to attorneys is really from the perspective of advocacy for the community standards. The ability to take the community standards and demonstrate their application in a given case. Therefore, there are times we represent plaintiffs, there are times we represent the defense, but always from the premise of being able to invoke the community standards on behalf of the circumstance that we are. Now, to get started, let me just introduce the concept of how hospital administration, healthcare administration differs from issues relating to clinical practice of medicine. As you all know, the corporate practice of medicine precludes hospitals from practicing medicine. We don't practice medicine. What we do is organize, manage, and develop the resources that are the environment of care. Now, from a historical perspective, I'm going to make a suggestion to you that may sound very surprising, and again, through your respective prisms of plaintiff and defense, you may each have different eyebrows raised. Over a 20-something-odd years of encountering attorneys on a random basis of fact pattern, in about 85% of the instances where there is a valid claim of clinical malpractice or wrongdoing by a hospital staff person, there is direct ability to demonstrate corporate negligence, not vicarious and not respondeat, but direct corporate negligence that runs to the senior executives. And it really has its roots in a very simple principle. The CEO has non-delegable accountability for that which goes on in the hospital. So to make this discussion meaningful, we're going to look at the linkage between the law. We're going to look at the concept of fiduciary responsibility and how it links to the CEO's responsibility for patient care, appreciate the non-delegable accountability of the chief executive officer, albeit in a very complex, large organization. We're not expecting the CEO to deliver patient care. We are expecting him to help it get organized and hold those who are delivering it responsible, and recognize the CEO's unique role in the concept of the medical staff. We'll get into that a little later. But to make this really meaningful to those of us in the healthcare industry, and again now I'm asking you to look at it through that prism, there's a series of moral imperatives that oblige the CEO in terms of his relationship in these various stakeholder groups that he has a responsibility for and to. And we have to connect the dots between the governing board, a given complainant, and the community at large, all other things equal. And in order to do this, you have to see the integration of the American College of Healthcare Executive Code of Ethics, which, by the way, is available at ache.org. ache.org. On their front page, you'll be able to see the Code of Ethics in full detail. There's a tab that'll take you there. And then put that context around that of non-delegable accountability for basically everything that goes on in the hospital and to these constituencies and stakeholders. We're going to look at corporate negligence along a continuum of senior people, because the Joint Commission standards talk about the concept of senior leadership, and this is who the senior leadership is actually comprised of. And if you stay with me, you're going to see us confront some really tough issues. We're going to look at the issues in the context of economic reality. We're going to look at systemic issues that once identified can't be ignored. And if we're successful, ladies and gentlemen, even among attorneys, we're going to stimulate some debate, because we want the healthcare leaders in the United States to really recognize that some of the old paradigms don't work anymore. And again, put this all in the context of accountability for the CEO and the governing body, those with fiduciary duty to the community. I'm not going to define fiduciary under the premise that you understand that. And if we're right in doing this, then we will have created the debate. We will create the challenge. And the reason we have to do this, folks, the system's broken. The healthcare system is not working properly. The Institutes of Health suggests that 98,000 people a year perish because of preventable circumstances. The estimate is that's anywhere from 100% accurate to 50% accurate. And to put it into a context that would not allow the same reaction, non-reaction in our system. Imagine what 98,000 deaths mean in the context of airline accidents. It's the equivalent of a 747 crashing once a week for 52 weeks. How many weeks would it take to shut down the system? But diffused over 5,500 hospitals, 98,000 deaths get lost. Now, let's take a look at some elements of the Code of Ethics. And this part that you see up here will repeat in all of them, so I'm not going to repeat it over and over again. We have to look at the issue first and foremost of quality of care in the context of services. We have to prevent discrimination and safeguards to prevent discrimination, and you'll see how that comes into play when we look at some physician issues later on. We've got to employ sound management practice and business practice. We have to behave in a way that avoids being false, misleading, or deceptive. And again, those of you that are evaluating testimony of percipient witnesses need to keep this concept of misleading and deceptive in mind, because there's the dimension of accuracy that is unavoidable. And we have to have an environment that's healthy, based on ethical conduct, ethical behavior. It's hard to say this, it's strange to say this, but the issue of sexual and other harassment is actually an emerging pandemic in hospitals and in nursing homes today. So the question is, why is this happening? What are we as management doing? And how does it translate in the context of legal questions that may come up to the question? And we have to create an environment that allows people to raise these concerns. Now, some of these things sound very, very basic and fundamental, but in environments that are not healthy, in environments that are toxic, it's these standards of ethics that are going to be put to the CEO to answer the question. Are you conducting the personal and professional activities in this hospital in the best interest of the organization and the best interest of the community it serves? And the answers are straight up. They are or they aren't. And again, to put the organizational of the hospital in its most simplistic form, it's really a three-legged stool. There's the governing body that has ultimate policy-making decision. There's the self-governing but not independent medical staff that renders recommendations on matters clinical, from clinical programs to specific credentials, privileges, and disciplinary action, and the chief executive officer who has a foot in both camps. But the underlying question here, folks, is it ethical, is it responsible, and does it pass the smell test of ethics, all other things being equal? Now, let's just take a look at some of the fundamental duties and responsibilities reserved to the governing board. They have fiduciary duties. They literally decide all hospital policies. Everyone, including the medical staff, is in a recommending posture to the medical staff, to the governing board, excuse me. They grant privileges. Doctors do not grant privileges. The medical staff, through its committee system, recommends. And they accept responsibility and the exposure to liability for everything that occurs on the hospital campus. The case law is specific on this. It goes back to Darling and other cases of long-standing repute, and the evolution of that is very consistent with that. Now, again, the duties and responsibilities that accrue to the medical staff. Self-governing does not mean independent. Self-governing means that the medical staff is left to engage in its activities through an independent set of mechanisms. It has its own committees. It chooses and elects its own officers, albeit with the ratification of the governing body, and it makes recommendations to the governing body for that which it feels is in the best clinical and medical interest of the institution and the members of the medical staff. But again, the key word is recommend to the governing body. There are instances where there's a delusion to believe that somehow the medical staff has an independence. It exists merely as a function of the corporate bylaws, no more, no less. And the medical staff rules of the road are the medical staff bylaws, and those don't come into play unless they're adopted, approved, and ratified by the governing body. Now, they make recommendations in these areas, and make no question that we rely heavily on the clinical expertise, knowledge, wisdom, and experience of our physicians in their collective. But again, it's in the spirit and the principle of recommending. No more, no less. Now, the CEO has some very interesting responsibilities. First and foremost, he or she has non-delegable accountability for literally everything that goes on in the hospital, with the exception of the medical staff, which has a direct reporting relationship to the governing body. But if you look in the corporate bylaws of any accredited hospital, you will see that one of the duties assigned to the CEO is medical staff oversight. They expect the business of the medical staff to be done under the overall oversight of, or said differently, no business of the medical staff can be done absent the oversight of the medical staff. The expectation is that the CEO read the minutes of every committee, be personally present at every committee meeting of meeting of the medical staff, or have a senior proxy, someone in a direct reporting relationship, present at such meetings. Now, without exception, in my experience over 40 years, the Chief Executive Officer attends the Medical Executive Committee, the last committee that ultimately is the basis for formal recommendations to the governing body for implementation. So the CEO knows or should know of all activities that are occurring in the medical staff, and is actually empowered, and I'm not going to go into the details of the empowerment, but in the corporate bylaws of every hospital, you'll see the tools and equipment granted to the CEO. Now, let's put this in context. Is the medical staff being asked to be, are they children? Are they being dealt with in a suffocating way? No. I think what you need to appreciate is the overriding principle of hospital organization. And that is that wherever there's foreseeability for something to go wrong in our environment, it's a very dangerous, potentially dangerous, complicated environment. We're open 365, 365. Human beings make mistakes, those are unavoidable, equipment breaks down. So wherever there's the opportunity of foreseeability, we have to build in systemic redundancy. And you see that in electrical feeds, two electrical feeds, standby generators. You see the duty of the pharmacy department to review medical orders. You recognize the duty of nurses to be advocates, not to challenge doctors' orders, but to advocate for the patient. And the oversight process of the CEO is indeed just that. It's the systemic redundancy to assure the governing body that the medical staff is following the rules of the road that were ratified to create structure and process for the recommendations of the medical staff. And therefore, he serves as an ex officio member, reads the minute, functions as a liaison between the two, and one of the tools that's available is to activate a committee to sidetrack recommendations to senior trustees, senior physicians who can deal with a controversial or inappropriate issue in camera. Now, the fact of the matter is, when the day is done, the combination of the direct non-delegable accountability and the oversight puts the CEO in an accountability loop for everything that goes on in the hospital. Now, what's the source of the authority for all of that which I'm saying? They're in 42 CFR of the Code of Regulations that define the conditions of participation, and here are some of them. 482.12 is for acute care hospitals, and we have the Joint Commission on Accreditation. It used to be called JCAHO. We're now, the acronym is now Joint Commission. And here's the standard for leadership. LD stands for leadership, and it describes the duty and necessity of and role of the governing body. Now, one of the things we have to look at before we start looking at what happens when and if things go wrong is the concept of how the industry, the environment has changed as a result of the acceptance of the principle of marketing. And that is now common among professionals. Attorneys are engaged in marketing. Consulting firms are engaged in marketing. Hospitals are engaged in marketing. But when you look at it, again, in the context of its implications to the hospital, it is really a triple-edged sword. And what I mean by that is, at one level, marketing is simply marketing 101, competition for market share, imaging, branding, and the like. At another level, without thinking of propaganda as a pejorative here, but rather just as a word, propaganda means attempting to influence individuals, either physicians to come and affiliate with the hospital and use the facility for the mutual benefit of them, the hospital, and the community, but it's an attempt to influence. And at your level, what your colleagues have taught me is that marketing also carries with it a series of implied warranties and inducements to the public that they rely on. Come here. It's safe. We're accredited. We've been voted top 100 in some poll. Our physicians are leading edge. And these are comments that are made in good faith, but sometimes the ramifications of them are not fully understood by the people making these statements. And in the context of holding accountability, in the context of a legal action, the implied warranty dimension of marketing is a very serious issue that both attorneys need to look at very closely. Are we making statements we cannot fulfill? Are we making statements that are erroneous? Okay? And here's the places you see these things. You see them in the admission packets. You see it in hotlines. You see it promoted on billboards. You see television ads. You see infomercials. And you even see it in airline magazines. For some of the larger chains are advertising in magazines. So here's the context and the framework of what I'm going to do in the next part of the presentation, and that is demonstrate to you what happens when things don't go the way they're supposed to. But the cases that you're going to see are going to focus not so much on the tortfeasors, the people who committed the act that is the triggering of the alleged injury, or the defense of what is not accruable to the hospital. But we're going to look at it through the prism of accountability. And not only look at what happened, but more importantly, in my opinion, as a hospital executive, why did this happen? And the why takes us into the culture of the organization. And once we understand the why, the context of what not only becomes clarified for the triers of fact, if you will, but it also gives a dimension of understanding that will make the case very clear for all parties. So, having gotten to the first question and answer point, I'd invite any questions on these issues, any clarifications, or that which you may want to discuss.
Okay, great. Thank you, Arthur. We do have a question here from Dana who asks, does a hospital have a duty to respond and recognize restrictions on a physician's license imposed by the state licensure board? Does the hospital have a duty to protect patients from practices prohibited or limited by the board with regard to a physician which has admission privileges?
Absolutely. And in fact, during the application and the biannual reapplication process, that is one of the questions that is asked and needs to be answered. And in the context of how we do business, subjected to independent due diligence. So no matter what the answer is by a physician in respect to have your privileges in any way been impacted by a state, federal, state, or any agency, or any professional society, or have you lost your privilege or have them modified at another institution or been subject to disciplinary action, there's a duty of the hospital to independently develop due diligence to verify that the statement is accurate. And the best way to describe that is just assume for the sake of the moment that an individual doctor who had a privilege to do procedure X is now prevented from doing procedure X. The hospital has to restructure the privileges, and it has to build in systemic redundancy so that if the physician attempts to book that case, it's stopped at the scheduling office as one form of systemic redundancy. And if that should fail for whatever reason, if it's misbooked or mischaracterized to the scheduler, once the physician is in the operating room, the circulating nurse, very similar to the launch director of a space shuttle, has to go through a pre-launch checklist to ensure that all is ready to go, and among that, she has to go to an up-to-date, real-time database or Rolodex that defines the physician's privileges. And if, in fact, they have been modified and this procedure ostensibly looks like it's being attempted, she has to stand the case down. So not only do we have to do it, but we also, again, in the principle and in the context of, of maximizing patient safety, we have to have systemic redundancies built in to prevent it from happening.
Okay, great. Thank you, Arthur. We have a follow-up from Dana who asks, does the hospital have any duty to communicate these restrictions and concerns to its ER who receive the affected patients?
No. No, it's an internal process. The physician practice is not transmitted to the ER because the emergency room is a portal through which patients come. If the premise is it's a member of the attending staff whose privileges are limited, it in no way affects the care, if I understand the question correctly, given by the emergency room physicians. It affects the care that the individual has. Now, if it's an emergency room physician whose privileges are restricted, it raises a larger question. If they can't service all comers as they are supposed to, they probably ought to be disqualified from working in the emergency department and prevented from working in the emergency department.
Okay, great. Arthur, we do have another question that asks, it's about the bylaws and what you had talked about kind of in the first couple of slides. How often should hospitals review and amend the bylaws and make sure that the bylaws are being adhered to? Is there a set of best practices that you can reference?
Well, first off, there's a community standard promulgated by the Joint Commission that mandates that all hospital policies, including corporate bylaws, have to be reviewed de novo every 2 years. So it's not less than every 2 years. The corollary to that is the hospital must engage in appropriate governing board member training, orientation, and continuing education. And that falls in significance mostly to the chief executive officer to ensure that there's a educational process, that there's a curriculum, and that the curriculum is indeed based on best practices that senior members of the organization, physicians, senior executives learn themselves by going to continuing education seminars, and as and if and when the Joint Commission expresses new standards, new sentinel alerts on issues that may require changes in bylaws.
Okay, great. Thank you. We have a question here from John, and I'm going to hopefully ask this question correctly. What is the effect of payment or waiver of payment by hospitals to a patient or for a patient in response to alleged claims of malpractice?
Well, I'm going to answer the question slightly differently. The emerging concept in hospitals today is to recognize that if something did go wrong once a complainant brings that forward, is to engage in a de novo review, and if in fact the hospital concludes they've got something wrong, is to recognize that, concede the fact that it was done, reassure the patient that if there's any monetary issues, the attorneys and the appropriate agencies will deal with that. If part of that goodwill gesture is forgiving outstanding balances, if there is a balance to the patient, that's a demonstration of goodwill and policy. But frankly, the issue isn't really about money from what the studies demonstrate. Patients don't sue hospitals more than likely over money from every survey I've ever seen. They sue hospitals over rage and anger of being dismissed, diminished, not taken seriously. And the studies have shown at the VA and the studies have shown at Minnesota Children's Hospital, as an example, that when you come to the patient in good faith, concede liability, and actually apologize, say you're sorry, and most importantly, demonstrate the good faith to say we've used this case to change our system and we're committed to never letting this happen again. Patients relax, they sue 50% as often, and and it demonstrates that most patients are really recognize the reality that hospitals are complex organizations. Later on in the bibliography, ladies and gentlemen, you're going to see a reference to sorryworks.com. And that is really a website that was put together by the pioneers at the Lexington VA that developed the concept that I've just described that is now national policy for all VAs. And by the way, I'm very proud of my former organization, Cedars-Sinai. If you recall the Dennis Quaid incident with the twins that were given a medication, literally the next day, the vice president for medical staff was on television saying we've investigated and unfortunately we're forced to say we made an error. And we appreciate that, and we're taking the necessary steps to deal with it. That's the modern way. So the issue of financial forgiveness is an example of demonstration of good faith.
Okay, great. Why don't we move on to the next section?
Okay, now I think the next section will be actually more important. If I put you to sleep in the first section, I think I'll wake you up here. Because now I want to show you a number of cases that literally demonstrate the principles of what happens when it goes wrong. But the subtext of every case that I'm going to show you really deals with the issue of the role of the CEO and the concept of executive management and executive accountability. And ladies and gentlemen, I'm talking about my colleagues. I'm talking about the standards that I was trained to develop. And I'm not suggesting that any one of us are perfect, me included. But there's a sobriety of issue related to patient safety that only recently has begun to get priority in the healthcare organizations. And we're going to look at these issues in the context of community standards. The case studies are all masked so that they all have Australian cities as the names of the hospitals. Again, I have no interest in calling anybody out. This is a teaching process, and it goes to a very interesting issue. There are many of you who probably have never heard the terminology sham peer review. And we'll get into that later on, and it's last so that hopefully I'll keep you awake until that point in time. Here's an issue that goes straight to the question of credentialing. It deals with a neurosurgeon who presented the following profile. License revoked in 2 other states, notwithstanding that the hospital gave him unrestricted privileges on its first application. And the fact is the Joint Commission says you cannot give anyone unrestricted privileges because you have to have the physician demonstrate currency and competency. So not only did they ignore some realities, they went ahead and exacerbated it by eliminating one of the systemic redundancy of requiring him to demonstrate his competence. Fact of the matter is the CEO is present at all these meetings. 2 years later, the man was re-credentialed. But now, having 2 years of experience in this community, stories were emerging in the newspaper. The guy created his own procedure that was never approved. CEO's present at the meetings. The fact is the hospital's department took him off their list to deal with employees, but they didn't revoke his privileges to serve the community. Think about that. The HR department took him off the approved doctors list, the surgeons. But they still allowed him to practice on members of the community. And practice comes into play in this case in a figurative sense, a literal sense of the word. He also lost his privileges at the HMO, lost his liability insurance, and yet they didn't take away his privileges. And here are the opinions that were rendered in this case, and these are my opinions. Unilaterally granted him privileges, knowing there were pending actions, 9 previous malpractice actions, and licensure resignation. And they approved them and reapproved him. He made this up. There is no such thing. He used that for marketing purposes. He says, I'm an expert in micro-laser discectomy, self-defined. Hospital didn't even investigate this. Ladies and gentlemen, this borders on the border of human experimentation. Now, if only the hospital behaved properly, recognizing the errors were made, there would not have been a lawsuit, or if there was, it would have been dealt with in a different sense. But now I'm almost embarrassed to give you a sense of the hospital's argument. Testimony under oath. Okay? Yeah, this guy's been sued 10 times and lost his license in 2 states. We didn't know that he had licensing problems. Effectively concedes negligence by admitting he doesn't understand the due diligence procedures required before you can even act on an application. Now, the Vice President for Medical Services made it a profound statement. Now, if you're laughing, I hear you. It's incomprehensible. And then the health system president, this is a senior person in a corporation testify. They're separate. The medical staff's separate. What does that have to do with the hospital? This is a regional corporate executive with the audacity or the ignorance to make that statement. And these are the things the hospital literally forgot to do or ignored. And the CEO had a duty to interrupt this before it got to the governing body. Failed to discharge the systemic redundancy and force the question. Now, why is this happening? Can anybody think of a reason why? Well, there's a couple of reasons. And the most significant one that comes to play is the economics of a neurosurgeon's value to an institution. There are others, and we'll see them as we go through, but the issue of economics is seductive and corrosive to the ethical construct and the community standards required to operate properly. Case study number 2. This has to do, again, with credentialing. This is a podiatrist who never had a surgical residency, yet the hospital's requirement is that you have a surgical residency in podiatry if you want to do podiatric surgery. They renewed his privileges 3 times over 8 years. And in one instance, the chief of surgery, tongue-in-cheek, said, you know, probably a good idea if this guy had a residency. Notwithstanding the chief's admonition, they reappointed him. Now, the hospital's defense was, wait a second, we didn't have to do any of that. We had a pre-existing grandfather clause which allowed us to do that, except that it wasn't approved by the governing body, and it wasn't in writing, and it was hearsay. Now, the jury awarded $7.75 million. And this is a case that went up on appeal in the state in which it occurred. The damages the individual suffered did not warrant $7.75 million. The damages, if you wanted to get pecuniary about it, were probably worth well under $1 million. But the infuriation of the jury about the chronicity of this. Now, what didn't come out in the trial was that this was a major source of revenue to the hospital. Once on the staff, this guy was doing hundreds and hundreds and hundreds of surgeries a year. And the fact is, the facts speak for itself. It was about money. Now, it isn't always about money in the direct sense of the word. Sometimes it's about politics, and sometimes it's about politics and money. VBAC stands for vaginal birth after cesarean, and that was a policy concept that was developed in the late 80s, if you will, to address what appeared to be disproportionate percentages of cesarean sections in our healthcare system, basically as a result of what was perceived to be defensive medicine. So VBACs for a long time were being encouraged, but in this environment, there's certain things you have to do. And in this instance, the patient wasn't informed that all of the necessary circumstances that the hospital has to prepare in the environment of care just weren't there. They didn't disclose to the patient that the single greatest risk, a rupture of the uterus during labor, the hospital could not sustain a C-section consistent with the requirements of the American College of Obstetrics and Gynecology. And that there was significant risk that if she had this VBAC in another institution would not be present. As you can imagine, there was a catastrophic birth trauma of twins, in a state with a microcap. But the specials came to $32 million. $32 million for life care for 2 twins who were severely, severely traumatized. And here are the unequivocal opinions. And by the way, ladies and gentlemen, in each of these cases, there was no opposing expert to argue that the hospital got it right. And in fact, in about 95% of the cases where I'm offering a plaintiff's argument, there are no experts on the other side. And it's not a function of me. It's a function of cases being as strong as they are and cherry-picking the cases. These are the opinions. And they run to the CEO, ladies and gentlemen. They run to the CEO. And these are the duties and responsibilities that he absolutely had to ensure before you could invite a patient to a risky procedure according to the American College of Obstetrics and Gynecology. We are mandated to implement those standards. And we need to give the patient a fully informed consent. And if we don't do that, we can't possibly defend ourselves. Now, here's a case involving the emergency room. Patient had very serious GI surgery. These are all GI procedures, and at the end of the procedure, ultimately the patient was ostensibly discharged in a steady state with serious abdominal pains that was not being, was on very big doses of meds and couldn't sustain a regular diet, notwithstanding that the patient was discharged. They returned to the emergency room within 24 hours, which is a major red flag, clinically. No diagnostic studies were ordered. Second visit, within the next 24 hours, wasn't even examined by a nurse or a physician. And this is an issue of EMTALA, anti-patient dumping issues. Patient dies. Straight up. Patient's dead. Now, did it have anything to do with the patient had no Medicaid and no insurance and was truly a charitable case? Left to conjecture. Left to conjecture, but the facts kind of speak for themselves. Now, these were the duties and responsibilities that had they been done, there would have been no lawsuit, notwithstanding if the woman died or not. That's almost not the issue here, although obviously I don't want to in any way trivialize the death. That's not what I'm trying to say. Clinical assessment. Steady state. A screening assessment on reappearance. Steady state. And being examined by a physician. And they couldn't discriminate between somebody in there with a cold, lumps and bumps and a person presenting with major symptoms. The nurse wasn't involved in advocacy. Advocacy of nurses, RNs, they're the only class in the entire hospital job description that is mandated to advocate. And I'll give you a very simple, penetrating definition of advocacy that you should use in every instance where it's an issue. It's what a parent does for a child. That's what an adult child does for a senior parent. And the question of advocacy is the systemic redundancy that is expected of RNs. Now, we have two more cases, and I want to get through them relatively quickly to allow for some additional questions. This goes specifically to the issues of policies and procedures. Nothing to do with credentialing. Patient postoperatively has a cardiac arrest. Two nursing supervisors run the code, but they couldn't even intubate the patient in that time period. They didn't draw any blood gases, and there was no cardiac monitor until 5 minutes into the code. It took them 19 minutes to start an effective IV. And nobody in the room had advanced cardio life support training during the first 5 minutes, the critical element of time that's necessary, and no records were kept of cardiac rhythms in this case. Or if they were, they weren't included in the medical record. Now, the testimony will tell you everything you need to know about what's right and wrong. This is actual testimony under oath. She said, look, anytime I have to get some information, just check the manual. Yeah, but are you going to do that in the middle of a cardiac arrest? The assessment done on the patient was done by a nurse aide, an untrained individual who ends up with a blood pressure of 100/40, reports that to the nurses that the blood pressure is fine. But when asked about the acuity level, that was a level 4, she said she didn't know what that means, and she didn't know if 1 or 5 was the highest or the lowest. This is the person who's reporting a blood pressure over 100/40. Now, the house supervisor says it was okay because it was okay. The fact that it took us 20 minutes made it okay. There were strips, we just threw them away. And it's not really part of the medical record until we put it in the medical record. But if we throw them away, they're not part of the medical record. So therefore, we have no duty and responsibility to preserve the monitor strips. And goes on to say this is not an unusual occurrence. Literally testimony under oath, ladies and gentlemen. The irony of this case is the hospital was advertising that they had a board-certified interventional cardiologist on site 24 hours a day. No such person was in the hospital. No such person appeared at the code. And then they testify, we complied to the best of our ability with ACLS. And then went on to insult the intelligence of the jury by suggesting that the code went quite smoothly, but the patient died. Now, again, in the context of modern evolving theory of sorry works, does this make any sense? No, it doesn't make sense. And by the way, these are all jury trials. These are not things that settled on the doorstep of the courthouse. Now, to move along to the last case, given to leave time, you may not appreciate the individual whose name is Ignaz Semmelweis. He's actually a disciple of Lister, and in the 1850s was the chief of OB in a Philadelphia hospital. And to put it, since I can't interact with you directly, I'll give you the question and answer in one word. Anybody have a sense of what the death rate was in obstetrical wards postpartum in the 1850s, 1860s in acute care hospitals in the United States? Answer, over 90%. Puerperal fever, childbirth fever was pandemic, and women with a half a brain did everything they could to not go to the hospital. It was a death sentence. Dr. Semmelweis discovered the vector, the basis for it, and the cure, and was basically presented his information to the Philadelphia Medical Society. They dismissed his arguments as specious because he demonstrated that the doctors themselves were going from the office to attending deliveries, wiping their hands on their butcher block smocks, attending postpartum, wiping their hands on their butcher block smocks, attending autopsies, wiping their hands on their butcher block smocks, and infecting the next cycle of patients. And when he challenged the authority of physicians or the behavior of physicians, he was dismissed, he was censured, and ladies and gentlemen, he died in a mental hospital crazy because he reduced the death rate in his ward to 5% by requiring hand washing with sterile product via, as a disciple of Lister, antiseptic technique, between touching patients. And as soon as his doctors and residents did that, the death rate dropped to 5%, and organized medicine would not accept those findings until much later on, and he died a crazy man. Sham peer review has the same characteristic, and the physicians in the United States who have been victims of sham peer review, the maluse of the peer review process to punish very qualified physicians, they took their namesake with Ignaz Semmelweis because they realized that what he discovered in his day mimics the denial that's going on in the healthcare industry about sham peer review. In this case, Polliner, and this is an actual case because of the reasons you'll see, is the watershed case and the landmark case in the United States about sham peer review. Here's the quick fact pattern. 6 cardiologists at the hospital ganged up on Polliner because Polliner was a Harvard-trained interventional cardiologist, came down to Texas and began to impact the economics of these 6 cardiologists. They reviewed 44 of his cases, and they alleged 29 of them to be substandard. They reported this to the MEC. Polliner requested an external review and deferral. They rejected it. He requested a 3 days postponement to prepare for the MEC. They rejected it, and they gave him an hour to defend 29 cases. Okay? They recommended suspension. It was appealed. They brought in outside people who said, wait a second, there's absolutely nothing wrong with Polliner. The board actually reinstates him. But he said, I want my record expunged. So there's no record in my thing of any suspension. And the board said, you know, we're not going to do that. We have some duty to the good old boys here, so we'll reinstate you, but we're leaving your record as it is. Files a lawsuit. 3 nationally recognized cardiologists testify in his behalf. Jury finds for Dr. Polliner and held 3 of the physicians liable. And they award $366 million. Texas case. Now, it was appealed to the Texas Supreme Court, and it was reduced to $76 million. It was appealed to the Supreme Court that elected Mr. Bush, and it was thrown out on a procedural technicality. But the reality is sham peer review, a function of the excruciating new pressures on physicians economically that now amplify and multiply the classic problems of politics in hospitals, ego, power, and control, are now extrapolated to a higher level because of economic penalties, and the maluse of the peer review process is being applied to otherwise very qualified doctors. And here's the reality that this gives the notice to the to the CEOs and the board. And you must follow these rules of the road. And if you don't, and you turn a blind eye, and that's also referenced to you in the bibliography, it's a book on malcredentialing, you will literally put your organization in harm's way. So, again, I'd like to open the audience, invite the audience to questions.
Okay, great. Thank you, Arthur. We do have a couple questions that have come in since the last Q&A break. So Dana asked, what is the standard of care with regard to treat and street drug addicts?
Anybody who presents at a hospital has to be dealt with in the following way. They must be evaluated by a qualified medical examiner, and I'm quoting from the EMTALA, Emergency Treatment Federal Legislation, EMTALA. It's the Anti-Patient Dumping Act. They must be evaluated by a qualified medical examiner, and that could be a properly trained nurse or or a physician, and they must be discharged in a stable condition. Those are the duties and responsibilities of the hospital. If either of those are violated, the hospital is at risk for an EMTALA lawsuit.
Okay, and a follow-up to that, can you specifically talk about those patients who suffer from mental illness?
Well, there you have each state has its own protocol for generating a mandatory hold. Hospital staff are trained. There are definitive policies, procedures that are used when that circumstance exists. Initially, you have a duty to meet the requirements of EMTALA, and then you have the duty until you properly process the individual to maintain that patient in a safe environment. I don't think, and again, I'm not a clinician, so be careful with my answer, I don't think you have to worry about the symptoms of withdrawal unless they that are merely palliative. In other words, I don't think you have to give the guy a fix, but I think you do have to maintain that individual in a safe environment until an appropriate order from the court for involuntary hold is made, or the patient is discharged to a responsible party.
Okay, great. We now have a question going back to something you discussed during the first part of the presentation, but that you touched on during the second part, and it has to deal with marketing. How would you advise a hospital to avoid some of the pitfalls that you talked about in marketing, saying that they are the reasons leading, or putting something in their marketing pieces that would imply warranty? How can hospitals avoid that and make sure that but at the same time make sure they put together convincing marketing pieces?
That's a great question. That person should get a cookie. That is a super question. The answer is, in my opinion, and it goes to the basic premise of how you run and operate a hospital. It starts with an awareness of the issue that stimulated the question, and the ability through various educational mechanisms, house organs, newspapers, meetings between senior executives and management, meetings between employees and management to promote the message that, ladies and gentlemen, this is what we're telling the public. This is what our commitment to the public is. We in senior administration recognize that we can't make the claim unless we can walk the walk and talk the talk. It's not only about imaging and branding. We recognize it. We want you to recognize it. And we're going to run the hospital. We're going to deploy the resources against these criteria. So if we say our staff is trained, we're going to commit the resources to your training. And in turn, we're going to hold you accountable by testing you, making sure the skills that you're supposed to have, you do have. If you don't, we're going to help you remediate that so that at the end of the day, we can live up to our claim. We want to be the hospitals we project. But it doesn't happen because someone gives us a label. It happens because we invest the management energy, the focus, the professionalism, and everything it takes to get it right. Now, I'm going to offer you a very interesting metric, again, from my 27-plus years of being involved in legal matters. Probably 80-plus% of all major cases that are properly brought against a hospital outside of sexual assault cases have their etiology in the ER, OR, and labor and delivery. And credentialing. Medical staff oversight. Issues of credentialing and physician supervision, for lack of a better word. Now, those are pretty focused areas, ladies and gentlemen. That's where the resources need to be focused to the nursing staff, particularly in those areas. They need to know the law. To have nurses in the ER not understand EMTALA, for nurses not to understand advocacy. And by the way, the advocacy policy marries up to a hospital, an administrative policy of having a senior administrator on call 24/7, 365, so that whenever, Christmas night at 3 a.m., if a patient's needs are not being met by usual and customary operating systems, that a senior executive can be notified so they can interdict and bring other things to bear on the circumstances. So it's a question of the attention to maximizing patient safety. And this was the message that this was all about to the members of the American College of Healthcare Executives. And this presentation has been made 5 times over the last 5 years. And it's really about the statement in a nutshell. Ladies and gentlemen, patient care and patient safety must be priority number 1. And we can go into all the reasons why it isn't. That's not the purpose for you. But the point is, the industry has remediation to do at a management accountability, at a training level for graduate students entering the field, evolving the sophistication of governing board members to make us, these CEOs, more accountable, training and education. The patient care and the patient safety message must be mission 1. And unfortunately, it's just not the way it is. It's about business, it's about systems, it's about politics, and too many of my colleagues are getting lost and trapped in those issues and not dealing with the reality that we're in the patient care delivery business. We're organizing the environment for the delivery of medical care. And that's why, and that's how.
Okay, great. Thank you, Arthur. We have one final question, it looks like, from Steve, who asked, and he starts it out with a fact pattern. A patient climbs out of bed twice in a hospital due to steroids before the hospital orders a sitter. The patient suffers a severe fracture on the second fall. Should you focus on the doctor's negligence, who is an employee of the hospital, or the CEO's failure to ensure safety, or both?
I would argue that 2 is more important than 1, but 1 can't be ignored. In other words, the fundamental duty is to safeguard the patient, whatever it takes. Now, obviously, you can't break the law and impose restraints where there are no restraints. But you don't have to be a rocket scientist to know that a patient is agitated for whatever reason they're agitated, and to take the necessary remedial interventional steps to solve the problem. And coming out of bed once is notice in the spirit of the legal dynamic. It's notice. You got a problem. You can't ignore it. But you also can't ignore the responsiveness of the physician. And that's where the advocacy duty is. If it wasn't ordered, it's not okay that the nurse called the doctor at 12 o'clock and now it's 3 o'clock. If there's a need that's real, it's got to be dealt with immediately. And if it isn't dealt with through normal process, you escalate the issue and you get it solved in real time.
Okay, I don't see any other questions in the queue, so Arthur, if you have any concluding remarks, go ahead.
Just to take you through a few more slides at the end, here are some cases of interest for those of you who want to look at sham peer review. It is a very significant and emerging area. These are anecdotal cases that I just put in because I've been involved in them, but they didn't materialize. The first ones are actual cases that went to court. In the back, you're going to see things that I would invite you to explore. These are websites or people that you need to know about. Here's sorryworks.com. And Gordon Alexander is a CEO and a pioneer in the implementation of sorryworks.com. He was featured in the healthcare literature. He was ahead of the curve, and his work is important. For those of you who want to see some really focused agendas, here are some books that are very important. One written by Newland. This book is a mandatory read for anyone involved in a malcredentialing issue of any kind. It is something I demand of every one of my graduate students. This is a book that Westlaw commissioned us to write, which took us 2 years and was published in October 2009. You can see it on the Westlaw website in their bookstore, but anybody who wants to order it, I would invite you to call us because we can arrange free shipping, a 45-day review period, and a 20% discount if the order comes through our office. And here are some things that I've actually written on the subject. This deals with the imperative that is the foundation for Sorry Works. It was written before it became common. This article mimics today's presentation, and this goes to the question of really what's not right in the nursing world